This podcast explores the workings of the criminal justice system, including the investigation and prosecution of serious offences involving sexual and physical violence. Episodes may contain detailed and sometimes graphic accounts drawn directly from case files, witness testimony, and court proceedings, including those involving adult and child victims. Listener discretion is advised. Welcome back to Criminal Justice in Action, the podcast that examines the criminal justice system in England and Wales in practice, how the system works, why it works the way it does, and when and why it doesn't. Every season, we'll be focusing on a different topic. This season, we're tackling one of the most contentious issues in criminal justice today, the investigation and prosecution of rape and serious sex offences, or RASO cases as they're increasingly called. Now, rape and sexual assault, they're issues that trigger a considerable amount of research and debate, most of which is highly, if not scathingly, critical of the criminal justice system's handling of these sorts of cases. We're told that the police don't believe complainants, the Crown Prosecution Service don't prosecute unless conviction's a sure thing, and that if a case even gets to court, and most don't, juries don't convict. In short, we're told rape's effectively been decriminalised and that men in the UK rape with impunity. Now, most of us haven't been involved in a RASO case, so we don't have first-hand knowledge or experience to draw on. And the press, well, they don't tend to report on rape cases, not in any detail, unless there's a high-profile figure in the dock or something particularly sensational about the case. So we started in episodes 1 and 2 by going to court and observing a rape trial for ourselves, a real rape trial in a real Crown court. We watched how that trial proceeded, and we saw the jury convict quickly and decisively in a case that, according to the mainstream narrative, shouldn't have even made it to court. It was the wrong kind of rape and the wrong kind of victim. But we saw the jury convict unanimously in around 45 minutes. We left Tariq's trial wondering whether that was a one-off, a fluke, an exception to the rule. So to test that, we're going back to court. Another trial, another defendant, another rape case that the mainstream narrative, the conventional wisdom, tells us shouldn't succeed. Why? Because the rape complainant in this case is a sex worker, an escort, a prostitute. And according to the prevailing narratives, sex workers are the epitome of the wrong kind of victim. This reflects what's often called the Madonna-whore dichotomy, the cultural tendency to divide women into two camps, the virtuous and chaste who are deserving of protection and belief versus those seen as tainted, less credible, less deserving of legal protection. Now, in this case, the complainant doesn't need to be artificially painted or squeezed into one of these categories by the defence or by the jury. She openly identifies as a sex worker. She is unambiguously in the whore camp, although I'm personally really uncomfortable using that term. Anyway, the point is that on the mainstream account, in terms of credibility, this victim is at the very bottom of the believability hierarchy. So let's see what actually happens at trial. I'm Dr Candida Saunders. This is Rape on Trial, Episode 3, Jerome's Trial. Another chilly Tuesday morning, and we're in another Crown Court somewhere in England and Wales. We're here for a trial listed to start today in Court 4. Like last time, all we know for now is that it's a rape trial. When we take our seat in the public gallery, there's only us, the prosecutor, Mr. Palmer, and the court clerk present. The judge isn't here yet, neither is the defendant, and neither is his barrister. Mr. Palmer isn't the prosecutor's real name. In fact, none of the names you'll hear in this trial are real. I've anonymised everyone and everywhere, just like I did in Tariq's trial, and as I'm going to be doing throughout the season. Every name you hear, whether of people or places, it's a pseudonym. Caveats in place, let's get back to Court 4. We've been sitting here in the public gallery for a while when a tall robed figure swishes into the courtroom, wig in hand. This, it turns out, is Mr. Dyer, counsel for Jerome, the defendant. Mr. Dyer's been in conference with Jerome all morning. Mr. Dyer's telling the prosecutor now that the defendant might be ready to plead guilty to at least some of the charges. There's some back and forth between the two barristers and their clients, Jerome in the case of Mr. Dyer, the Crown Prosecution Service in respect of Mr. Palmer. But in the end, however, Jerome isn't going to plead. This is the problem, Mr. Dyer tells the prosecutor. He's not too bright. The trial, then, is going ahead. His Honour now takes the bench. There's a quick discussion of how long the case is expected to run, an estimate that, as you'll see, doesn't go to plan. The judge is also alerted to a couple of legal applications that may need to be heard in due course. With the morning largely taken up by negotiations, it's already lunchtime. The judge proposes that court should rise now for lunch with a view to empanelling the jury and beginning the trial this afternoon. It's almost 3 o'clock by the time the jury's empanelled. His Honour gives the standard opening remarks to the jury, reminding them it's their role to judge the facts, to do so dispassionately and putting aside any assumptions they may have about rape. He warns them not to discuss the case with anyone, not to do their own research, and explains they'll see different types of evidence, videos, statements, live witnesses, all of it to be weighed in the same way. It's routine stuff. We saw it in Tariq's trial. It takes about 10 minutes. Then the trial gets underway with Mr. Palmer's opening speech. He introduces both himself and Mr. Dyer, defence counsel, to the jury. He tells them this is a case about the robbery of 5 women and the rape of 1. There's no dispute that those crimes took place, he says. The question for the jury is simply who committed them. The prosecution's case is that it was the same man each time, Jerome, and that the evidence will prove that. Mr. Palmer explains that all the women were sex workers, advertising online and taking bookings over the phone to meet clients in hotels. Each thought they were meeting a client for what prosecuting counsel politely describes as a normal transaction, in other words, paid sex. Once inside their rooms, however, the man robbed them, sometimes armed with a knife, once with a handgun, and on one occasion he raped his victim. None of the women knew each other, says Mr. Palmer, but when they spoke to police, their accounts of events, what happened and how, they were all very similar. He tells the jury that the prosecution says the evidence points to Jerome. There's CCTV footage showing a man with a distinctive walk and consistent clothing, he tells them, and phone data, he says, linked to 2 mobile phones, the number of one ending in 2468 and the other ending in 1357. Both phones, says Mr. Palmer, are associated with Jerome. Both phones were used to contact the women, and both phones place Jerome at the different scenes. There's also identification evidence, the prosecutor says. 2 of the complainants picked Jerome out in formal police identification procedures. Mr. Palmer now directs the jury to the indictment in their bundle, and he takes them through the individual charges. Before we go through those charges with Mr. Palmer, though, a quick word of explanation. In court, the jury's given the exact dates for each incident. In the interests of anonymity, I'm not giving you those dates. I'll give you the sequence of events so you can follow the cases the jury did, but for our purposes, specific dates don't matter. There are 6 counts on the indictment, and they're listed in chronological order. Count 1 is a robbery charge, which in terms of timing happened around a year and a half before Jerome's trial. The complainant in count 1 is Natalie. Natalie was at the Riverside Hotel in City A when she received a call from a man using the 2468 phone number. He made a booking with her for later that day. As he was leaving the room, the man grabbed Natalie by the throat, threatened to kill her, and stole between £2,000 and £3,000. Mr. Palmer's playing some CCTV footage from the Riverside Hotel. It shows a man entering and walking through the hotel. The prosecution says the man in the footage is Jerome, says Mr. Palmer, but that is a matter for you to decide. As we watch the footage, Mr. Palmer's telling the jury to look at how careful the man in the video is. He's checking exits, he's avoiding touching lift buttons. Savvy, says the prosecutor. He points out the man's hat and that the man's holding what looks like a phone in his hand. Phone data, he tells the jury, places the phone with the 2468 number in that very corridor at that very time. We see the man in the hat enter a hotel room, Natalie's room. The footage then skips ahead and we see two members of the hotel staff approach that hotel room door, apparently listen and then walk away. Another skip in the footage and we see the man in the hat who, it has to be said, looks an awful lot like Jerome from where I'm sitting. We see that man leave Natalie's room and make his way out of the hotel. Moments later, we see Natalie fleeing the room, naked, running down the corridor. Later that evening, says Mr. Palmer, the same 2468 phone was used at a local casino. We'll call that casino Winners. Jerome's a registered member of Winners. Mr. Palmer shows the jury a still image taken from the casino's records. It's a photo of Jerome's driving licence, and it was used to sign into Winners Casino that night. There's also CCTV footage of Jerome at Winners. Mr. Palmer says there's also evidence of a man in that same hat topping up the 2468 phone at a supermarket later that night. That supermarket, says Mr. Palmer, is within walking distance of Jerome's home. Coincidence, he asks. On to count 2, another robbery. About 2 months after the incident involving Natalie, Jade was at the Station Hotel in City C. She was contacted by a man using the 2468 phone. Having entered her hotel room, the man grabbed Jade from behind as she closed the curtains. She'd already been to the bank that day and only had £60 on her, which the man stole. He forced her to undress and lie on the floor before he left. Here too, Mr. Palmer's playing CCTV footage to the jury. You see Jade arriving at the hotel, speaking on a phone, and it also shows a male entering the hotel a little later. Through cell sighting evidence, says Mr. Palmer, we can establish that the man on the CCTV is the man who robbed her. Does he look familiar, he asks. Is the man's gait the same? Is his build the same? Does that hat look familiar? Now to count 3, another robbery, this time of Claire, and it took place a couple of weeks after the robbery of Jade. Claire was working out of the Parkview Hotel in City B. She took a booking from a man calling from the 1357 phone. When he entered her room, the man immediately threw Claire to the floor, produced a handgun and threatened her. He took around £1,500, told her to undress and to lie on the floor before he left. Note the similarity to count 2, says Mr. Palmer. Reports that were made independently of one another. Again, we're watching CCTV footage of a man entering the hotel. We see him in the lobby and in the corridors, wearing the same hat, similar gait, similar build. Mr. Palmer pauses the footage and says, "The prosecution says this is Jerome. The defence will say it is not." Phone data tracks the 1357 number that morning, travelling from City A, which is where Jerome lives, to City B, which is where the robbery took place. 2 weeks later, Sophie was robbed at the Riverside Hotel in City A. This is count 4 on the indictment. Sophie was contacted by a man using the 1357 phone and a booking was made. Having entered her hotel room, the man spent 10 or 15 minutes chatting with Sophie, which, says Mr. Palmer, gave Sophie a good look at the man. He then grabbed Sophie by the throat, put her to the floor and took some £1,000 from her. CCTV footage is played of the man arriving at, moving through and eventually leaving that hotel. Mr. Palmer says that later that evening, phone data places the 1357 phone at Winners Casino in City A, where Jerome's a member. The prosecutor tells the jury that when Sophie saw Jerome in an identification procedure, she told police, "That's him, 100,000,000%. Now to the final counts on the indictment, counts 5 and 6, both of which relate to Hannah, 1 count of robbery and 1 count of rape. Hannah's evidence will be presented to you by video, Mr. Palmer's saying. That doesn't make it any less true or untrue. He tells the jury that Hannah was at the Central Hotel in City B. She took a booking from a man using the 2468 phone. When the man arrived and entered Hannah's room, he immediately attacked her and stole her money and jewellery. This is count 5, the 5th robbery charge. Hannah was screaming. Jerome stuffed a newspaper into her mouth to silence her and threatened to stab her. Then he raped her. That's count 6 on the indictment. 1 charge of rape. Again, CCTV from the hotel is played with some accompanying commentary from the prosecutor. He's wearing different clothes and hats, says Mr. Palmer, but I'll come back to that, he says. Look at his gait. Is it the same walk? And look, he says, the man's carrying a newspaper. Following Jerome's arrest, says Mr. Palmer, police searched his girlfriend's home. They uncovered clothing and a hat resembling those worn by the man in this footage. Like Sophie, Hannah positively identified Jerome in a police ID procedure. At the time of his arrest, Jerome was in possession of 2 mobile phones, says Mr. Palmer. One was the 2468 phone, the second the 1357 phone. When interviewed by police, says Mr. Palmer, Jerome gave a no-comment interview. The prosecutor concludes his opening speech by reminding the jury it's for the prosecution to prove its case. Jerome, he says, has nothing to prove. You need to decide if you can be sure that it was the defendant, he tells them. The judge now asks Mr. Dyer if any of the robbery counts are being contested in terms of whether there was an element of violence. No, says Mr. Dyer, he won't be cross-examining on those elements. The defendant simply contends he wasn't there, says Mr. Dyer, so he won't be asking the women what happened in the room. Because the prosecution's case relies so heavily on the identification evidence of Sophie and Hannah, and because that evidence is disputed, the judge now gives the jury what's called a Turnbull direction. It's a warning to be cautious when relying on identification evidence and the risks of mistaken identification. Even honest witnesses can be wrong. Now, the timing of the Turnbull direction is at the judge's discretion, but they are typically given later in judge's directions and summing up. His Honour's choosing to give this direction now doesn't negate the need for it to be given again later. But in a case where eyewitnesses' identification evidence is plainly pivotal to the prosecution's case, and the defence is a flat denial, it wasn't me. An early warning against being swept along by a witness's apparent certainty when identifying an individual, well, it's likely to be helpful for the jury and it's certainly fair to the defendant. And this is just such a case. As the judge is telling the jury now, the only matter in issue in this case is whether it was Jerome or not. With that, court adjourns for the day, back tomorrow at 10 a.m. This is going to be an interesting trial. Day 2, back in court 4. We're here as usual a little before 10 a.m, which, depending on the judge, is when the court day generally begins. Unusually, only Mr. Palmer's currently in court. Mr. Dyer's nowhere to be seen, neither is the defendant. 10 a.m. comes and goes, 10:30, 11. Something's obviously going on, but right now we don't know what it is. All we can do is sit tight. Eventually, Mr. Dyer enters court. He's been in conference all morning with Jerome. The judge now enters the court and takes his seat at the bench. Mr. Dyer tells His Honour that the defendant wants fundamental changes made to the defence statement. He apologises to the judge. I'm aware a jury has been kept waiting, he says. And witnesses, says the judge. Mr. Dyer explains that he wants the defence solicitor to take a full statement from Jerome absent himself, as in absent Mr. Dyer. He tells the judge he would then like time to assess that statement, as he's not sure what its content will be and whether Jerome will be admitting presence. His Honour looks thoughtful for a moment. To state the obvious, he says, presence is vital in this case. Mr. Dyer asks if the jury might be retired until 2 o'clock this afternoon, and the judge agrees. His Honour then leaves the court. So does Mr. Dyer. You and I, well, we're going to continue sitting tight. 1:45, the judge is back. Prosecuting and defence counsel are both in court, but Jerome isn't. He's still downstairs with his defence solicitor. Given the defendant's absence, says the judge, he's only willing to discuss timelines. Jerome's new defence statement is likely going to take the rest of the day. He's aware, he says, that Jerome is admitting presence in relation to count 1, so the robbery of Sophie, but they're going through count 2 now, he says. Without breaching privilege, says the judge, he wants to know what the effect is going to be for witnesses. Mr. Palmer now advises the judge that not all the women were going to be called as witnesses by the prosecution, just Sophie and Hannah, the two that had identified Jerome. Depending on the new defence statement, says Mr. Palmer, that's now likely to change. As one of the witnesses is no longer in the country and can't be contacted, there'll need to be a hearsay application. And, says Mr. Palmer, given that they weren't all expecting to be called as witnesses, it may be difficult to call them in chronological order. That doesn't matter, says the judge. They don't need to be called chronologically. Realistically, though, says the judge, the defence is going to need until tomorrow lunchtime to get the defence statement in place and for Mr. Dyer to assess it and take instruction. The jury, who obviously aren't here for all of this, they're now going to be sent home until tomorrow at 12. So, in layman's terms, what's just happened? Well, it looks like, having spent yesterday watching the same high-quality video evidence of a man who looks remarkably like him emblazoned on the court's large video screens, and having heard Mr. Palmer setting out all the evidence the prosecution says proves the robber was in fact the defendant, looks like Jerome's had a sleepless night back in prison and decided that maybe his "it wasn't me" defence isn't going to fly with the jury. So, we don't know what he's going to say, but we know he's admitting being there now, and we know he's still pleading not guilty. So he's disputing something. He's saying, it was me, I was there, but we don't know what that but is yet. But the whole case is about to change in terms of both which witnesses the prosecution's going to want to call and what they're going to be asked about. In short, our interesting case just got even more interesting. See you back in court tomorrow lunchtime. Now Thursday lunchtime, day 3 of Jerome's trial, and we're back in court 4. And things have changed. Pretty drastically, but we'll get to that in a moment. His Honour and counsel are dealing with some procedural matters raised by the changes now. First, a hearsay application, which is granted. And second, an additional count that's being added to the indictment. That's count 7, possession of an imitation handgun. The jury's now brought in and proceedings get underway immediately. They begin with Mr. Dyer talking to the jury. He tells them that Jerome now accepts being the man in the women's hotel rooms and that he stole from the women, but, I told you there'd have to be a but he denies robbery. He denies any violence or threat of violence. He denies the production of a handgun in count 3 or a knife in count 5. He also denies rape or any sexual activity, consensual or non-consensual. The judge now explains to the jury that in law, robbery means the use or threat of violence in order to steal. The issue for the jury now is whether they are sure there was violence and therefore robbery, and whether the rape took place. His Honour tells the jury that all 5 witnesses are required now, rather than just the 2 who'd identified Jerome. As arrangements are going to need to be made by the prosecution, they may need to be called in a different order to the indictment. He also tells the jury that the complainant in count 1, Natalie, can't be contacted and her statement will be read in as hearsay. The first witness will be called in relation to count 4, he says, so that's Sophie. She'll give her evidence from behind a screen. He then gives the jury the special measures direction that we heard in Tariq's trial. In essence, that this is entirely normal in these sorts of cases, doesn't affect her credibility and has no bearing on the defendant. The publican Jerome are cleared from the courtroom so that Sophie can be brought in without being observed. Once she's settled, we're allowed back in. It's 12:25. Mr. Palmer begins by pointing out that there's no dispute that at the time she was working as an escort, and Sophie agrees. She also confirms that she advertised her services on an adult website. As her evidence continues, Sophie tells the jury she was working at the Riverside Hotel that weekend. By Saturday evening, she had around £1,000 in cash with her, her earnings, which were hidden under the iron in the room. That afternoon, she'd taken a call from a polite-sounding man, the man she later identified as Jerome. He booked a meeting for 8 p.m. He arrived a little late, she says, but she let him in. They chatted for a good 15 or 20 minutes, just small talk, holidays, life, nothing unusual. When Sophie asked whether they should get started, she says she instantly knew something wasn't right. His whole attitude changed in that moment, and that's when he attacked. He instantly took me to the floor, she says, and choked me, his arm around my neck and his knee pressed into my back. She describes being held like that for 5, maybe 10 minutes, face down, on her stomach, in a chokehold, terrified. Jerome demanded money. Sophie told him where it was. Still in a chokehold, he forced her to crawl on her knees across the room to fetch the money and hand it over. Then he made her empty her handbag. He went through her purse, taking more money. He looked at her passport and threatened to find her and kill her if she went to the police. He made her disconnect her phones, take a SIM card out, battery out. Then he forced her to strip naked and lie face down again. She kept asking him what was going to happen next, she says, but he didn't answer. She was convinced he was going to kill her or rape her. That was the most scariest part, Sophie says. I don't understand why he didn't just take the money and leave. It was torture. I didn't know if he was going to take my life or rape me. She cries. And she apologises for crying. Both Mr. Palmer and the judge reassure her there's no need to apologise, and, says the judge, if she needs to sit down at any point, she should. In the end, says Sophie, the man left. He went out slowly, she says, without a care in the world. As he left, he told her, I'm only doing what I'm doing because you're doing what you're doing. Sophie phoned reception straight away. Staff came immediately to her room. You obviously told them something of what had happened, says Mr. Palmer. Yes, says Sophie. She'd told them she'd been robbed, but she hadn't told them she was working as an escort. She was embarrassed, she's saying. Because it wasn't me. I've worked all my life, she says, but I'd got into debt. That was the only reason I was doing that stupid, silly job, she says. Sophie tells the jury she stopped sex work immediately after this incident. Mr. Palmer asks her to look at a photograph, which she confirms is a photograph of an injury on the right-hand side of her face. It was taken by police at the beginning of their investigation. He asks her to explain how she got this injury. It was from the pressure of his arm around the side of her mouth, she says, while she was in the chokehold. That's the end of Sophie's evidence in chief. It's taken about 10 minutes, and she goes straight into cross-examination with Mr. Dyer. Now, remember, the defence position now is that yes, it was Jerome in her room, and Jerome stole from Sophie, but he didn't use or threaten violence, so it's a theft, not a robbery. In case you're wondering, this matters because if Jerome's convicted, well, when he's convicted, given he's admitting theft, but if he's convicted of robbery rather than theft, that'll attract a higher sentence. In short, then, a successful defence here, no robberies, no rape, would mean a lesser sentence. It wouldn't mean Jerome walks free from court. The aim of Sophie's cross-examination, then, is to challenge her account of what happened in that room, and Mr. Dyer's approach to doing that is threefold. First, he's suggesting it was a simple theft and that Sophie wasn't even in the bedroom when Jerome stole her money. He suggests that Sophie was keen to get to the reason for Jerome's visit, the sexual activity. She wasn't wanting to chat and waste time, and that after they'd chatted, to push things along, Sophie had gone into the bathroom to get yourself more comfortable, he says, to get yourself ready. Sophie rejects this. She never went into the bathroom, she says. Mr. Dyer continues, "Isn't the truth of the matter that once you got into that bathroom, by the time you'd come out, he'd already gone with your money?" "No, not at all," says Sophie. "That's a lie. That's not true." Second, Mr. Dyer points to inconsistencies in Sophie's accounts. The first inconsistency is that she told the hotel staff she'd been robbed after going out with friends and that she'd been followed back to the hotel. This was a different story to what she told police. And Sophie admits she lied to staff at the hotel, but insists she only did so out of shame about her sex work. Her account of what happened in the hotel room, she repeats, is the truth. But her initial account to staff, she accepts, was a lie. The second inconsistency Mr. Dyer raises is the various accounts she's given as to how she ended up on the floor. She's described being pushed, being grabbed, and tripping. Mr. Dyer's asking her now what actually happened. Was she pushed? Yes. Was she grabbed? Yes. Did she trip? Yes. Mr. Dyer's now suggesting it can't be all three, so which is it? "He put his 2 arms round my neck," she says. "It's as simple as that. There's no in-between. I stood up to get the money off him. He took the £10 note out of the back of his pocket, and I instantly knew something was wrong. I turned round, and within a split second it was all over. I was on the floor. He was choking me out. That's what happened." Mr. Dyer moves on to discuss what he's presenting as another inconsistency, her injuries. He's pointing specifically to the photographic evidence of bruising on Sophie's face, which she says came from struggling while she was being choked. But there are no photographs of bruising to her neck. "No," agrees Sophie. The insinuation then is that the evidence of Sophie's injuries isn't consistent with, it doesn't tally up with her account. She's got marks to her face, hives, Mr. Dyer's calling them. She's got hives on her face but no marks on her neck. He asks if she can explain why, if the defendant's choked her like she said he did. Why are there no marks on her neck? She doesn't know, she says. She was sore, but she's not a doctor. She can't explain why the marks on her neck didn't show. Mr. Dyer now moves on to his third line of attack. He's about to set up a motive for a false or at least exaggerated allegation. "That £1,000 that you say you lost," he says. Sophie's immediately interrupting him. "It wasn't lost," she says. "It was stolen. It wasn't lost." "That £1,000 that was stolen, that meant a lot to you, didn't it?" "Yes," she says. "You were doing something you didn't want to do. You had to make a difficult decision to go into that industry. That £1,000, that's a lot of money." "Yes, it is," she says. "Is it the case that you were so angry that he's stolen this £1,000 from you, that you've made up that he robbed you? You made up that he threatened you? You've made up that he assaulted you in the way you described?" There's a pause. Then Sophie says, "What for?" "To get back at him," says Mr. Dyer. "To get back at him for what? He's admitted he's taken it," says Sophie. "It's not the money, it's what he's done to me. He's destroyed my life," she says. "My whole family have had to watch me suffer." Mr. Dyer's talking over her. He's saying something about, "Is that why there are no marks on your neck?" But the judge interrupts him. "That's a comment," the judge tells Mr. Dyer firmly. "It's not a question. You can say that in your speech." "Yes," says Mr. Dyer. "I have no further questions, Your Honour." Mr. Palmer has no further questions either, so Sophie's evidence is complete. In total, she's been on the stand for about 32 minutes. It's almost 1 o'clock. Court rises for lunch, back at 2. Court's a little delayed getting started again after lunch. It's 2:26 when Jade, the second prosecution witness and the complainant in count 2, takes the stand. Like Sophie, Jade's subject to special measures and is giving her evidence from behind a screen in court. Mr. Palmer confirms her name, then takes her through some background, like he did with Sophie. At the time, Jade was working as an escort. She advertised online and was using the Station Hotel in City C. She made a booking with a man who arranged to come to her room. That man, she tells the jury, was the defendant. He arrived a little after 11 in the morning, she says. She'd let him in through the security doors to her floor and then into her room. Once inside, she says, he looked behind the bathroom door, which she thought was strange. She moved to close the curtains, and that's when it happened. Out of the blue, she says, Jerome grabbed her from behind and had her in a headlock. He'd got his body pressed tight against hers, his arm clamped round her neck. He told her over and over, don't shout, don't move, do what you're told, and you won't get hurt. Jade says she was crying, shaking, not knowing if he was going to rob her, rape her, or kill her. Still in the chokehold, Jerome forced her to shuffle across the room to where her bag was. He told her to empty it, which she did. He didn't touch anything, she says. She emptied her bag, her purse. She'd already been to the bank that morning and only had £60 cash on her, which Jerome took. He made her switch off both her phones. Again, he didn't touch them. He took her inhaler, and he took a sweet that had come out of her bag when she tipped its contents onto the floor. He put the wrapper in his pocket. The man told her to get up, and she had to lean on the bed to push herself up. When she did that, Jade says, he rubbed himself against her, saying, look what you've done to me. She could feel he had an erection, she says. Then he told her to take her clothes off, which she did. He ordered her to lie face down on the floor with her hands on her head. She was still crying and shaking, still not knowing whether he was going to rob her, rape her, or hurt her. He just kept saying to her, do what you're told and I won't hurt you. The whole thing lasted around half an hour, maybe 40 minutes, she says. That's the end of Jade's evidence in chief. Cross-examination begins straight away. Mr. Dyer's got the same aim as he did with Sophie, which is to challenge her account of what happened in the hotel room. But this time he takes a different approach. Mr. Dyer sets out the defendant's stall almost immediately. Just so that you are aware of the position of the defendant, he says, and of course I represent him in this process. What he's saying is, he is the man in that room, he was the man in that room, and he did steal the money from you, but at no stage did he issue you with any threats, and at no stage did he offer any violence towards you in any way. I'm just setting that out so you know what he's saying. What do you have to say about that? Well, it's not true, says Jade. Mr. Dyer then focuses his questions on something that hasn't come out in the evidence so far. Jade didn't actually report this incident to police. Now, obviously, she did make a statement. Jerome's on trial for robbing her, amongst others, but how she came to be a complainant in the case hasn't been covered yet, either in Mr. Palmer's opening or in the evidence. And that's making things a bit confusing in court right now. So rather than leave you in the same what's going on position that I'm guessing the jury's probably in, I'm going to give you a quick explainer. Claire, the complainant in count 3, who we haven't heard from yet, she's the only one of the 5 complainants who called the police directly. 2 others, Sophie, who we've already heard from, and Natalie, whose evidence is still to come in relation to count 1. They gave statements after the hotel manager contacted police about robberies at his hotel and passed on their details. Those reports triggered the police investigation that led to Jerome's identification and arrest. When he was arrested, he had 2 phones on him, the 2468 number and the 1357 number. Police seized and interrogated those 2 phones, and the call and message history suggested those numbers had been used to contact other women in the sex industry. Now, the police obviously can't risk contaminating evidence by calling those women saying, we've just arrested this guy for robbery, did he rob you too? Instead, police made tentative, neutral inquiries along the lines of, we're investigating the man who used this number. He contacted you. Is there anything you'd like to tell us? Jade got one of those phone calls from the police, and yes, she did have something to tell them. He'd robbed her. That's how she became a complainant in this trial. Incidentally, this is the same investigative process that also led to Hannah's allegations of robbery and rape in counts 5 and 6. It's worth saying, this is solid police work, careful, proactive, investigative practice, and it's not the first time I've come across it in a sex case. But it doesn't fit the critical narrative we usually hear, that complainants, especially if they're sex workers, aren't believed and that their allegations aren't taken seriously by the police. Anyway, back to Jade's cross-examination and Mr. Dyer's point that she didn't report the robbery. If, as she claims, Jerome held her in a headlock, forced her to the floor and made her strip, Mr. Dyer's saying, why didn't she go to the police? Why didn't she warn them about a man who might do this again? Because she was scared he'd come back for her if she reported it. She says she stopped working for months afterwards, too frightened he'd find her. But Mr. Dyer won't let this go. Does she have friends in the industry, he asks her. Yes, she says. How would she feel if he'd done that to her friend? I'd feel the same, says Jade. I'd be scared to work. How would you feel if the man you didn't report... The judge cuts Mr. Dyer off. That's enough, he says sharply. Keep to the facts, please. The fact that it wasn't reported to the police. I'll move on, says Mr. Dyer. He repeats that Jerome accepts he was the man in Jade's room, that he stole from her, but that on Jerome's account, he just took her purse from her bag. This, says Mr. Dyer, is very different than what you've described. Would you agree? She would, yes. Far more serious than someone taking a handbag from a bed or a floor. Yes, she says. Isn't it the case that the reason why you didn't report this to the police was because that's what happened? Asks Mr. Dyer. He came into your room and he stole a purse from your bag and took that £60, and that he didn't threaten you and he didn't use violence. That's not true, says Jade. Because as he left that room, says Mr. Dyer, he had your phone and he had your purse, and you said to him, did you not, look, I want my phone back because I've got pictures of my children on it. No, says Jade, he didn't take my phone. And he threw it on the bed, says Mr. Dyer. He didn't touch anything, says Jade. He didn't take my phone. Mr. Dyer moves on. He suggests she took her clothes off voluntarily. No, she says. She did it because she was ordered to. He suggests Jerome never rubbed himself against her. Yes, he did, she replies. Mr. Dyer suggests there was no threat of sexual activity and that Jerome spent his time telling her, do as you're told and you won't get hurt, but didn't actually hurt her. Jade agrees that he said it again and again, but insists he held her in a headlock and terrified her throughout. No more questions. But Mr. Palmer has some. Jade, he says, what's very properly and likely being suggested to you is that you've effectively perjured yourself and you've made up things that never happened in your hotel room. Have you been doing that? No, says Jade. You're lying is the suggestion because you had £60 stolen from you. I don't wish to pry into all of your business affairs, but at the time, was £60 a lot of money to you? Not really, says Jade frankly. That was just spare change that I didn't bank. I'd been to the bank and that was just for like my daily things, coffee, food, things like that. I'm not going to be bothered with £60 when potentially I can earn thousands of pounds. Nothing further, says Mr. Palmer. It's 2:54 and we now do the empty the dock and the public gallery dance, but in reverse, so Jade can leave court without being observed. Once we're back in court, it becomes clear that the next witness, Hannah, isn't going to be called this afternoon now. Hannah's the complainant in counts 5 and 6, so the final robbery and the rape charge. Judges tend to bend over backwards to ensure that a rape complainant's evidence is dealt with in a single session. It's too late in the afternoon for all of Hannah's evidence to be heard now, her video evidence and cross-examination. The judge wants Hannah to be called tomorrow morning instead. The jury's sent home till tomorrow at 10 a.m. Once the jury's gone, the judge picks up on that gap in the evidence that we dealt with a few minutes ago. He asks Mr. Palmer if it will be in the agreed facts how complainants were identified, as the last witness hadn't come forward to police. It should be dealt with for the jury, he says. Yes, says Mr. Palmer, I can do that in questions to the officer in the case. That's the end of day 3. We're back in court for the 4th day of Jerome's trial. It's a little after 11 before the jury is brought in and proceedings get underway. Mr. Palmer, prosecuting counsel, tells the judge that he'll be playing Hannah's ABE video. Hannah's the complainant in counts 5 and 6, the robbery and rape. As is routine in rape cases, Hannah's evidence in chief isn't going to be live in court like Sophie's and Jade's evidence was. Instead, Hannah was interviewed by specialist police officers when she made her complaint. That interview was video recorded, and the jury will see that video now. Again, the judge gives the jury a special measures direction that this is routine and should have no bearing on their assessment of either the complainant's evidence or the defendant. The video then comes up on the court's large screen and Mr. Palmer hits play. We see a young woman sitting on a soft chair in a specialist interview suite. She's facing the camera. The video's around 45 minutes long. I'm going to summarise Hannah's evidence for you now. She explains that she's an escort and was working out of the Central Hotel in City B. She'd received a call from a man who made a booking for the following day. The same man then called back and asked to change the time. He asked if I'd been busy, she says, how many people I'd seen. I didn't think anything of it at the time. The next morning, there was a knock at the door of her hotel room. I looked through the keyhole, she says, and saw a man wearing a hat. I let him in, turned and walked into the room, and then he grabbed me round the throat. I couldn't breathe, she says. I couldn't shout for help. He repeatedly told me, shut up, and he pulled out a knife. He said if I didn't listen, I'd get stabbed. I was scared. I thought my life was at risk. She says he dragged her around the bed, put her to the floor, told her to lie on her front. He put his knee on her back and said, if you get up, I'll hurt you. Where's your money? He picked up her bag and told Hannah to empty it onto the floor. He told her to open her purse. There was about £1,300 in cash in the purse, and he told her to put the money on the floor. Then he took the money and said, turn around, don't look at my face. She says he's wearing sunglasses now. He wasn't wearing those when he'd arrived. Hannah says she was starting to worry why he wasn't leaving. She said he was getting angry when she asked him questions, so she kept quiet. But then she heard a housekeeper outside in the corridor and she shouted for help. The man immediately stuffed a newspaper in her mouth, telling her to shut up. She was kept on the floor, repeatedly being told to be quiet for about 5 minutes. Then the man told her to undress. Once she's naked, the man told her to turn around. He took a photo of her on his phone. Then he told her to get on all fours. I knew what was coming, she says. I heard him undo his belt and I started to look round, but he told me to turn around. Then he raped me. Afterwards, she says, he removed the condom he'd worn and he put that condom and its wrapper in his pocket. He took Hannah to the bathroom and told her to wash. He then took her back into the room and told her to get under the bed, but he still didn't leave. When he finally left, he picked up her top and used it to open the door. She says he told her, just to let you know, someone sent me here. I didn't want to do it. He said that if she followed him, he'd stab her. Once he'd gone, Hannah locked the hotel door. Crying, she called her mum and told her she'd been robbed and raped. She says she packed up immediately and travelled home. She says she was in a trance. When she got home, her mum told her to phone the police because he could do it to other people. There's some clarification and further detail sought by the officer, including around consent. Hannah's very clear on this. She was not consenting. Even though they'd arranged to meet for sex, she was not consenting. She'd shouted for help. She'd asked him to stop. She'd told him to take her money and go. Did you make it clear you weren't consenting is the officer's final question. Very, very clear, says Hannah. And that's the end of Hannah's pre-recorded evidence in chief. Court's briefly cleared so Hannah can be brought into court unobserved. We're going straight into cross-examination, which will be conducted live in court from behind a screen, like Sophie and Jade. Now, so far, I've been summarising witnesses' evidence for you. You've had all the key points and a lot of verbatim quotes, but it has been edited down. But I want you to hear this part of the trial in full, exactly as it happened, word for word, because I don't think it's what you're expecting to hear. And honestly, because if you don't see for yourself what cross-examination looked like in an actual rape trial where the complainant's a sex worker, an escort, if you don't see it for yourself, I'm not sure you'll believe me. So, to avoid any suggestions of editorial jiggery-pokery, you're going to hear Hannah's cross-examination in full. It's 12:02 when Hannah's sworn in. Mr. Palmer, the prosecutor, asks Hannah to confirm her full name and then tells the judge he doesn't have anything to ask beyond what was covered in the ABE. The judge does have a quick question for Hannah. The jury have just seen the recorded interview, he says. You will have seen it. There's no need for you to watch it as the jury did. But when did you see it? The last time I saw it, asks Hannah. I haven't actually seen it. Right, says the judge. Have you had the chance to look at it again in the last few days? Yeah, says Hannah. I didn't need to look at it. All right. Thank you, says the judge. He nods to Mr. Dyer, who immediately takes to his feet. He moves to the prosecutor's desk, explaining, I'd like to have eye contact with you if possible, okay? Presumably, Hannah nods, because we don't hear her answer, and remember, we can't see her, she's behind a screen. But Mr. Dyer's responded with a thank you. I'll be asking questions on behalf of the defendant today, all right? And what I'd like to do is I'd like to put his account to you of what happened in that room, okay? So he's saying he doesn't accept what you say happened. He says something completely different happened in that room. Do you understand? Uh-huh. That's what he's going to say, clarifies Mr. Dyer. Okay, says Hannah. So what I'd like to do is to set out and ask for your comments when I put to you what he says happened in that room. All right? Okay. Now, it's agreed that this defendant goes to your room, into the hotel room, and he goes there, and you believe there's going to be some sexual activity between him and you that he'll pay for at some point. Hannah agrees. Yeah. All right, says Mr. Dyer. What he says is that when he went into the room, there was a bed and there was a table at the end of that bed. Do you agree with that? That's correct, says Hannah. And there was a side desk. That's correct. A desk to the side. And what he will say is that on that side desk, Mr. Dyer stops himself. Sorry, he says, I'll start with the bed. On the table at the end of the bed, there was your handbag. It was a designer-type handbag, is that right? That's correct, says Hannah. Now, the judge interrupts. Forgive me, he says. Yes, says Mr. Dyer. The original question was, and it was a question, says the judge, was your bag on the table at the end of the bed? Mr. Dyer confirms that yes, that was his question. The judge thanks him. Mr. Dyer resumes his cross-examination of Hannah. When you make arrangements for people to come to the room, he says, how is that achieved? How do you go about that? Do you advertise on a website? How would that be done? So, basically, you advertise yourself on a platform, says Hannah. Yes. Mr. Dyer's nudging her to say more. And you display your number on that platform, Hannah continues, and then the client will call the number. You arrange a time where you are, and then that person just comes to the location. Yes, Mr. Dyer prompts again. And you give them the room number and they come up to your room, says Hannah. All right. And those bookings, that would be administered or orchestrated by you, Mr. Dyer asks. Yes, says Hannah. So the bookings would come into you and you would sort your diary out, as it were. Yeah, I manage my own bookings, agrees Hannah. Would that be done on a laptop? Asks Mr. Dyer. No, so it would be done via a call or a text message. All right, says Mr. Dyer. Would you use a laptop to organise your diary? Not really, no, answers Hannah. I do use a laptop when I'm at work, but I don't use it for that. All right, says Mr. Dyer. So you have a laptop, but you don't use that for work. You keep that to your phone. Yeah. Yes, repeats Mr. Dyer. The next thing that I'm going to put to you is that on that side desk, on the desk on the side of the room, your laptop was on that desk. Is that right? That's correct, says Hannah. Yes, repeats Mr. Dyer. And when he walked into the room, you in fact walked over to that laptop. When he went and sat on the bed, you walked over towards the desk by the laptop. Is that right? No, says Hannah. When he was sat on the bed, you were operating the laptop. He never sat on the bed, says Hannah. So when you were operating your laptop, what he will say is that you had your back to him. She interrupts defence counsel with a loud no. You had your back to him for a short period of time, is that right? Continues Mr. Dyer. No. When he came to my door and I let him into the room, he came in and I closed the door behind him. He made a comment on my appearance and then I walked in front of him, which is when he came behind me and wrapped his arm round my neck. He noticed my laptop was open. It's a Mac laptop. So when the webcam's on, it'll display a green light. Yes, prompts Mr. Dyer. And he saw that, says Hannah, and he immediately made me shut it. At no point did he sit on the bed. At no point. No, that never happened. All right, says Mr. Dyer. There was a discussion, Jerome says, in relation to what was exactly to take place in the room between you and how much that would cost and the payment for that activity. No, says Hannah immediately. Was there such a discussion, asks Mr. Dyer. That was discussed on the phone before I knew what his intentions were, says Hannah. When he came into the room, there was no discussion. He just made one comment on my appearance. When I opened the door, he said I was a really good-looking girl. I walked off in front of him, and that's when he wrapped his arm round my neck. Because his case, says Mr. Dyer, and I'll set it out to you so that you know exactly what he's saying. His case is that when you were at the desk and he was on the bed, he stole the money from your handbag and then left the room. No, says Hannah. You noticed, begins Mr. Dyer, but Hannah's interrupting him, talking over him. But Mr. Dyer's continuing with his question regardless. You noticed there was something wrong and asked for your money back, he says. Sorry, says Hannah. Say that again. What the defendant's saying is that he walked from the room, you noticed something was wrong, and you asked for your money back because you realised he'd been inside your bag, says Mr. Dyer. No, that's incorrect, she says. And begins Mr. Dyer, but Hannah interrupts again. This time, Mr. Dyer lets her speak. When he came into my room, and he did that to me, says Hannah, immediately I said to him, if you want my money's in a bag, and my bag's there at the end of the bed. Take my money, don't hurt me. I've got a child. Just leave me and just go. And he wouldn't. He continued. He wanted to hurt me. I gave him every single opportunity to leave and to take my money, and he wouldn't. He obviously had intentions to do what he did to me because I made it so easy for him. Hannah now begins to cry. Hannah, says Mr. Dyer gently, take a moment, please. There's a few moments' pause so she can calm herself. The judge interjects. Hannah, he says, it will be much better if we... Mr. Dyer will keep this, I think, pretty short. Yes, of course, agrees Mr. Dyer. It will be much better to carry on and finish, please, the judge says gently to Hannah. If you need a pause or need a break, you'll have it. But it may be much better. It's easy for me to say, but it may be much better if we just carry on and finish. Is that all right? Yeah, whispers Hannah. All right, thank you, says the judge. If you need to sit down, just do so, please. Yeah. All right, thank you, says the judge and nods to defence counsel. Hannah, says Mr. Dyer, the defendant's case is that he stole from you, but he did not take any money through the use or threats of force, and at no stage did he have sexual activity with you, consensual or otherwise. That's a lie, fires back Hannah. In your interview with the police that we've all seen, yeah, says Hannah, you mention at one stage you being on the floor. Yeah. And you couldn't see behind you because you're facing one way on the floor. Yeah. And you described that he's behind you, yes? Yeah. I think this is what you said. You say, I then hear a belt. He undoes a belt, yeah? Yes, agrees Hannah. What exactly did you hear? Asks Mr. Dyer. Did you hear the buckle go, or? I didn't actually know, says Hannah. I just heard like a rumbling, like a fumbling sound, like someone's undoing their trousers. Yes, repeats Mr. Dyer. And you knew what that was? You knew that was the undoing of the belt? Yeah, I knew what was going to happen to me, Hannah says. Yes, and you say then, so as a result of hearing him undo his belt in the position you were in, you say that you turned around immediately, yes? We don't hear a response from Hannah here. Linking the two things together, continues Mr. Dyer, your fears and what you heard, yeah. You turned around immediately, and you say that he said to you straight away, turn around now and face that way, face the other way. Is that right? Yeah, that's correct, agrees Hannah. And I think within the police interview, again, you're very clear that when he's finished, when he's ejaculated, you hear the same process of him doing up his belt, says Mr. Dyer. That's what you tell the police, yes? Yeah. And you're very clear on that, aren't you, that you hear the belt being done up? Yes, I just heard a fumbling sound like doing the jeans up, confirms Hannah. Yes. Well, I'll read what you say. I hear then, pull his boxes up, jeans up. I hear the belt again. That's what you've told the police, all right? Yeah. Just to be fair to you, says Mr. Dyer, that's exactly what you said, all right? Again, we can't hear any response from Hannah. Maybe she's nodded, maybe she's shrugged. I don't know. We can't see her. But Mr. Dyer continues as though she has responded. £1,300 was stolen from you, Hannah, wasn't it? He says. Yes. And that is a lot of money, isn't it? Yes. Have you made up the fact, or the allegation rather, that he robbed you and raped you to get back at him for stealing your money? He asks. No way, says Hannah quickly. I have no reason to make up something about someone that I don't even know and put myself through all of this. Because you didn't tell the police immediately, did you, says Mr. Dyer. No, I was really, really frightened. He threatened me and told me he'd kill me. He told me he'd kill my family. He'd seen my bank card, so he had my name. When he'd looked in my purse, he saw that. So I was just so frightened. He had a knife on him. Because when he left the room, you locked the door, yes? Yes, agrees Hannah. And there's a phone in your room, says Mr. Dyer. Yes. A hotel phone, and you have your own mobile phone. Yes, and I think you spoke to your mother, is that right? Yeah, I immediately called my mum. So you had the facility to alert the hotel and the police straight away, didn't you? Asks Mr. Dyer. Well, it was a shock. I couldn't believe what had happened. I was just frightened. He told me if I chased after him that he'd stab me. But you weren't going to chase after him, says Mr. Dyer. You'd locked the door, hadn't you? Yeah, I locked the door straight away. So he couldn't get in, could he? He couldn't get back in, agrees Hannah. He couldn't get back in, repeats Mr. Dyer. Yeah, agrees Hannah. Mr. Dyer moves on. The money that you earn from being a sex worker, he says, that money, that £1,300, is that all yours, or do you have to give a cut to somebody else? It's all mine, says Hannah. A slight pause from Mr. Dyer, then. Is the reason why you didn't report what you've told this court to the police at the time immediately because he stole from you rather than do what you've described? No, says Hannah immediately. I wouldn't make up something about someone that Why would I make up something like that? Mr. Dyer turns to the judge. Thank you, my lord. I have no further questions. Mr. Palmer? Asks the judge. Mr. Palmer nods and retakes his position at his desk. Just a very few questions, he tells the judge. Mr. Palmer looks at Hannah. £1,300 you lost, he says, and you accept that's a lot of money. I'm not intending to embarrass you in any way, shape or form, but did you have the ability to earn that money back? How long would it take to earn £1,300 in the line that you were in? It's probably a night's work, says Hannah. What's being suggested is you were so bothered by losing a night's work that you've made up an allegation of rape and robbery. That's absolutely Hannah interrupts but stops short while Mr. Palmer continues his question that she's made up an allegation of rape and robbery to get back at the person that stole the night's work from you. That's ridiculous, says Hannah. I would never make up allegations about someone that are untrue. The first person you told was who? Asks Mr. Palmer. It was my mum. When? Literally 5 minutes after he left, says Hannah. Again, not to embarrass you, Mr. Palmer begins. Did she know... Sorry, I put that clumsily, he says. Did she know at the time you made that phone call what line of work you were in? Yeah, my mum knows, says Hannah. She knew, she knows. Yeah. And she was the first person you wanted to tell? Yes. Thank you, says Mr. Palmer. He looks to the judge. Nothing further from my purposes, he says. Hannah's thanked for her evidence by the judge, who tells her, I think it's very unlikely that you'll be seeing any other person, any other witness in the case. But if by chance you do, please don't speak to them about the case. You wouldn't want to anyway, but it's very important that you don't even accidentally influence what any other witness might say. Yeah, of course, says Hannah. The dock and public gallery are cleared so she can leave the court. It's 12:18. And just in case you didn't notice, Hannah was on the witness stand for 16 minutes. As soon as Hannah's gone, we're allowed back into court. The judge is explaining to the jury that, as the defendant says he didn't commit the violence or the rape, the judge had agreed in advance with Mr. Dyer that counsel wouldn't ask questions that had been covered in detail in the ABE. In other words, he's letting the jury know that defence counsel's cross-examination of the complainant's been limited in terms of its scope. Mr. Palmer tells the judge he's about to read the statement of Hannah's mother to the court. We saw witness statements being read into evidence in Tariq's trial. It's not an unusual or a rare occurrence in trials. And the judge here, like the judge in Tariq's case, explains that this evidence isn't disputed by the defence. It's agreed evidence, so as there are no questions for her from the defence, the witness is simply not required to attend court. Mr. Palmer stands. He reads the declaration of truth at the top of the statement and confirms the witness's name. We're just going to call her Mum, or Hannah's mum. Hannah's mum says that she's making a statement in relation to her daughter. She says that at 11 a.m. on the relevant date, she missed a call from her daughter Hannah and called her back. As soon as Hannah picked up, Mum continues, she was crying. She wasn't making any sense and was hysterical. She was saying she'd been robbed and raped. She was in so much distress, says Mum. I kept telling her to breathe and calm down. Hannah said she was in a hotel in City B, that he'd stolen her money and jewellery. I told her not to worry and to make herself safe and to call the police or hotel staff, but she wanted to come home. I told her to pick her up, but she wanted to leave straight away. She called me when she was on the train home. I collected her from the station. She looked so upset. When we got home, she told me what line of work she was in. I wasn't pleased, but I wanted to support her. She told me what had happened, that she'd been raped, that he'd been forceful. I was concerned about disease and pregnancy, but she said he'd used a condom and had taken it with him. Mum recounts the description of the man Hannah had given to her, and that he'd made her get under the bed as he left. It's not a long statement, but it's a powerful one and it's emotive, despite having been read to the court by Mr. Palmer and the unavoidably neutral and detached voice that entails. He's not Hannah's mum. And it's unsurprising that the defence didn't want the jury to hear that evidence directly from Hannah's mum. It would likely have been heartbreaking. Court now rises for lunch, and we're going to pause here too. You've heard the prosecution's case take shape, and you've heard 3 complainants tell their stories. Join me in episode 4, where we'll see the remainder of the prosecution's case, hear from Jerome himself, and follow the trial through to its conclusion. If you've got questions or comments about this episode, I'd love to hear them. Email me at host@criminaljusticeinAction.com and your questions might feature in future bonus episodes. So that's host@criminaljusticeinAction.com. Looking forward to hearing from you. If you've been affected by any of the issues raised in this episode, please visit our website criminaljusticeinaction.com for information about support. Criminal Justice in Action is a Scrutiny Media production, researched, written and presented by Dr Candida Saunders, edited and produced by Candida Saunders and Gary Saunders, music by Elya Nursmanova.